I do have to file a Chapter 7 bankruptcy. What really happens? What's the mechanics of what happens? How many times do I have to go to court? What do I have to do? Those kinds of questions. Here's a rough overview of what happens in the average Chapter 7 bankruptcy. Of course, there will be exceptions to this. Most notable is if you have obtained any form of credit through fraud and there's a lawsuit against you within the bankruptcy to try to have one of your debts declared non-dischargeable, then we're talking a whole different ballgame. But basically the average bankruptcy goes like this. The first thing that you have to do is go to your mandatory consumer credit counseling course and get a certificate that you've completed that. And it's a good thing. They will take you through a series of questions to determine if there's any possible way that you could get on some kind of a debt repayment plan outside of bankruptcy and avoid having the bankruptcy as a black mark on your credit report. Assuming that you go through the counseling though and they don't find a good solution for you there, you get your certificate of completion of the course, and then we prepare and file a bankruptcy petition along with the schedules that list your assets and your debts, discloses your income and your monthly living expenses. There's a statement of financial affairs, a means test calculation to determine if you make too much money to qualify for a Chapter 7, and a statement of your intentions with regard to what you intend to do with collateral that you have pledged for different loans, like your house. Are you going to try to keep your house and reaffirm the debt, or you want to give the house back to the lender and walk away from it? Once we file all that paperwork, the day we file the petition, a freeze goes into effect. It's called the automatic stay. It stops all of your creditors from taking any further action to collect debt. It even is supposed to stop the debt collector phone calls. That freeze stays in effect for the duration of the bankruptcy unless the creditor files a motion in the court to have it set aside. A few exceptions to that, but that's the general rule. So then, a few weeks after that, and by the way, usually on the day that you file the papers, your hearing date is set, so you know when the hearing is going to be. But depending upon how backed up the court is, within a few weeks after you file the petition papers, you have your first hearing in the bankruptcy court. It'll usually be down at the federal courthouse, but it's usually not in front of a judge and not in a courtroom even. Here in the Sacramento Federal Bankruptcy Court, the Eastern District of California, there are informal hearing rooms where the 341 meetings are held. They're actually not even called a hearing, they're called the 341 First Meeting of Creditors, because the theory is that the creditors can show up at this meeting and they can ask you questions about the information that you've provided on your petition papers. But no judge is there. It's a bankruptcy trustee who conducts the hearing. He's usually a local attorney or a financially sophisticated person that's been appointed by the local bankruptcy court, and he's going to be the trustee for your bankruptcy unless someone objects. And he will ask you a series of standard questions he has, like did you read and understand the bankruptcy petition before you signed it? Have there been any major changes in the petition since the time you filed it? Are you expecting any inheritances within the next 12 months? And do you understand that if you do receive an inheritance in the next 12 months, you may have to pay it over to the trustee? A set of standard questions, and he may have a few specific questions about information that he's found in your paperwork, if there's anything in your paperwork that's not clear. Then he gives an opportunity for any creditors who have shown up to ask questions that they might have of you. Now, even though it's called the 341 First Meeting of Creditors, most financially sophisticated creditors understand that they're not going to be able to get much useful information at the 341 meeting, and most creditors don't bother to show up. Occasionally there will be some little paralegal or representative there from one of the big department stores saying, well, you know, what are your intentions with regard to that big screen TV that you bought on credit from our store? Are you going to keep it, reaffirm the debt, are you going to give it back, or are you going to redeem it? But otherwise, your hearing usually lasts 5 or 10 minutes and then it's over. And most people are terrified when they go in, shaking in their boots, some in tears. but you go in the hearing room and you look around and you see almost everybody else in the room is another scared debtor like you or their attorney. And when it's over in 5 or 10 minutes, usually the same people who were scared to death going in come out and they go, "Whew, is that all there was to it? Wow." It's over. If there have been any problems with your paperwork or the trustee's not satisfied with the documents that you brought or he has further questions, then the hearing may be continued and you may have to come back again another day for another hearing or a continuation of that hearing. But assuming that the paperwork was okay, and this is one reason why it's so important to get the paperwork right the first time, then when your 341 hearing is over, there really isn't much else that you have to do except that you must complete your budgeting class, the second class you're required to take. It's a class on managing your finances so that you don't get in trouble again. You have 45 days to complete that class and get the proof of completion of that class into the bankruptcy court. If you get your 341 hearing successfully completed and your budgeting class completed, then a few weeks later your notice of discharge comes to you in the mail, and that is the document that proves that all of your unsecured debt has been discharged. And your secured debt, you have to decide whether you're going to give the collateral back and walk away from the debt, or you're going to reaffirm those debts and keep that collateral and just keep making the payments. So that's a general view of what usually happens in a Chapter 7. I hope you see that it's important to get the paperwork done right, and that's why I hope that you'll look for a lawyer to help you get your bankruptcy papers put together and also perhaps represent you at the bankruptcy hearing. If you have to do a bankruptcy, God bless you and good luck.